Welcome, everyone. Thank you for joining us today. I'm Peter Dutton. I'm an adjunct faculty advisor to the U.S. Asia Law Institute, and I'm adjunct professor of law at NYU School of Law and currently interim dean at the Center for Naval Warfare Studies at the Naval War College. I'd like to welcome you to today's program. It's called Testing the Boundaries, Conflict and Contest in the South China Sea. Next week, we've got another program coming, I want to mention, which will be on Wednesday, November 3rd. Our guest speakers on that day will be Gregory Schaefer and Chantal Thomas, two leading U.S. trade academics. And they'll be discussing the current state and future of U.S.-China trade relations. That program is called Governing U.S.-China Trade Relations, and that will be at an unusual time slot for us. It'll be 12 p.m. Eastern Daylight Time. So we hope to see you there. So my guest today, as I said, is Jonathan Odom. He's a commander in the U.S. Navy's Judge Advocate General Corps. He's currently serving as a U.S. Navy military professor of international law at the George C. Marshall European Center for Security Studies in Garmisch, Germany. He previously occupied a similar post as a military professor of law and maritime security at the Daniel K. Inouye Asia Pacific Center for Security Studies in Honolulu. You know how to pick duty stations, Jonathan. He served as the Ocean Policy Advisor in the Office of the Secretary of Defense. He's been Deputy Legal Advisor to Commander U.S. Pacific Command. He's been Assistant Special Counsel to the U.S. Chief of Naval Operations. He served in Japan in direct support of Operation Tomodachi, as a matter of fact. He's served in Iraq, in Al Anbar province, in Kosovo. He served aboard U.S. amphib called the USS Bellawood. He served in the Arabian Gulf in support of Operation Southern Watch. So Jonathan has been around the world handling international law issues as a U.S. Navy JAG. As a scholar, Jonathan's principal areas of research and teaching are public international law, maritime security, and international territorial and maritime disputes, which sound very familiar to me, which is perhaps why Jonathan is here with us today, because our work overlaps so much. It's a pleasure to work with you so closely and for so long. In this area, Jonathan's widely published in law journals, edited volumes, and other sundry places on various aspects of international law. He's lectured and presented literally around the world. And so it's my pleasure to welcome you today, Jonathan. We're honored to have you. Before we dive into the program, you and I first met, I think, about 25 years ago. Isn't that right?
Oh, you stole my intro.
Oh, did I? Okay, go ahead. Over to you then.
Yes. No, I was going to say that on Twitter in the past week, I've seen a lot of postings about this being the 50th anniversary of the PRC taking the seat in the Chinese seat in the United Nations. And what I also know is that I turned 50 this year. But more importantly, it was 25 years ago this month that we first met. And that was when you were my professor at the Naval Justice School, and I was a brand new lawyer in the U.S. Navy. And you were not a brand new lawyer in the U.S. Navy. So anyway.
No, that's a very polite way of putting it. You're right. I was not, 25 years ago, I was not a brand new lawyer in the U.S. Navy.
So no, thank you for having me, and thank you to the Institute for inviting me to participate today. So I look forward to discussing.
Yeah, it's a real pleasure, Jonathan. You know, I'm sure that there's, you know, you've been teaching for long enough now that I'm sure you've had this experience as well, that there'll be the occasional student that you just don't forget. And I will tell you, you were the first one of those for me. The first student that just, you know, memory of our interactions just continued, you know, over the years. And it's been a real privilege to work with you and to see your career just absolutely flourish over the years. Speaking of which, you know, we're here to talk about one of our favorite topics, right, which is the South China Sea. Would you mind giving us an overview? I know we've got a couple of slides. Sure. Maybe what we should do first for the audience is to is to do an overview, kind of around the horn of the South China Sea, and we've got a slide. I'll share my screen here in just one second.
You're doing that. Let me make sure I include the required disclaimer that the views that I share today are my own personal views and not necessarily those of the Marshall Center, the U.S. Department of Defense, or anybody else in the U.S. government.
Thank you for doing that, Jonathan. Yeah, I need to do the same, since I am also currently employed by the United States government as Dean at the Center for Naval Warfare Studies. The opinions are my personal opinions here today as well. So Jonathan, just to make sure this is working right, are you seeing the map of the South China Sea?
Map. Yep, I sure do.
Great. Okay, tell us what you see.
Yeah, so I suspect that we have quite a few veteran South China Sea watchers in the audience today, but then there may be people at different levels of information. So I think one of the most valuable things was to put a map on the screen from the beginning and provide kind of a thumbnail sketch of the situation. And we, by all means, Peter, you chime in where you want to. But what I would just say is, there are 6, 7 or so claimants. And so you see them around the horn there in the darker red: China, Vietnam, Philippines, Malaysia, and Brunei, with Taiwan in smaller letters, obviously, because it brings into the question of China, Taiwan's status. And then I also include Indonesia in a lighter shade of red. And the reason why I do that is traditionally, Indonesia has not viewed itself as a claimant. It's viewed itself as one of the more influential members of the 10-member ASEAN Association, but it doesn't view itself as a South China Sea claimant. But what has happened in recent years is that kind of like Al Pacino in Godfather 3, they're kind of getting pulled in by a lot of the behavior by the PRC. And so there were situations, I remember a few years back, there were statements by the Chinese government in Beijing. They were asked, so what about the disputes you have with Indonesia over the Natuna Islands? And they said, well, we don't have a territorial dispute with Indonesia, but as to maritime disputes, I'm not going to discuss that at this time. And I was like, whoa, was that a non-denial denial by Beijing? And then fast forward, in the months thereafter, there were several incidents where Chinese fishermen were fishing not just in the EEZ off the coast of the Natuna Islands, but actually in the Territorial Sea off of the Natuna Islands.
Just briefly, Jonathan, could you
sure.
describe the difference between those two things?
Sure. Yes.
Some of our audience may not know.
Generally, a coastal state's allowed to claim up to 12 miles of territorial sea off their coast.
Fully sovereign.
Yes, exactly. Sovereign territory, subject to a few rights that other nations have, like the right of innocent passage. But then from 12 up to 200 miles, a coastal state can claim what's referred to as an exclusive economic zone, which, as the word says, exclusive economic zone. It's an economic-based zone for fisheries, oil if you're not from the American South, mineral resources. And so the coastal state gets first dibs on it. They have what's referred in the treaty to the Law of the Sea Convention to sovereign rights of fish, sovereign rights of oil and mineral, natural resources. So up to 200 miles. So in this situation, as I was describing, Chinese fishermen were fishing within the sovereign territorial sea of Indonesia without the government of Indonesia's permission. And there was one situation where the Indonesian Coast Guard equivalent arrested a Chinese vessel. They were pulling it to port, and the Chinese Coast Guard showed up and started ramming the fishing vessel to the point that the Indonesians had to release the tow line for safety's sake. And so,
speaking of Chinese Coast Guard vessels, this morning I saw the news that that China has just launched a 13,000-ton Coast Guard vessel. I mean, this is bigger than most Navy vessels, right? Most destroyers and cruisers are smaller than this type of vessel. So the Chinese Coast Guard has some very formidable vessels.
So with regards to a kind of around the horn tour, what's important to note for those who may be less familiar is that you have the two main island groups in the center of the South China Sea, that is the Paracels and the Spratlys, but not every claimant state claims everything, okay? So Vietnam, China, Taiwan claim both the paracels and the spratlys. But the Philippines, Malaysia, and Brunei don't claim the paracels. They claim portions of the spratlys, primarily those that are in their EEZ. But in general, they claim some of the spratlys. They don't claim all of the spratlys. And those three countries also don't claim any of the paracels. And so the paracels are currently occupied by PRC, and the spratlys, that's really the soup sandwich. That's where multiple claimants are occupying different features, and they're not occupying the features that are closest to their coastline. So they're all overlapping, and that's where there's probably, one could argue, the greatest potential for friction between the claimant states.
Yeah, coming back to Indonesia, Jonathan, I'm looking down here at the map and I see kind of a dark blue line. And then I see, if you look closely, you can see the dashed line we'll talk about later that reflects China's, the extent of China's claim. And there seems to be some overlap there.
Exactly. And that's the thing. On the one hand, you could say, well, the reason why, even though Indonesia does not want to view itself as a claimant in the South China Sea and is not part of these disputes, it's primarily because of China's behavior that they're getting pulled into the situation. So I jumped to talking about the territorial sea violations that Chinese fishing vessels were engaged, but even which are the most egregious. But setting that aside, I think from Beijing's perspective, what you're saying is because of that one of those dashes, you see waters within that dash overlapping the clear 200-mile EEZ of the Tuna Islands. That's one of the reasons why China has refused to comment on whether they have a maritime dispute or not with Indonesia.
Yeah, it appears to be that overlap must be at least one of the sources of the friction. So what other countries do you want to discuss in some detail?
Yeah, I think with the Philippines, over to the left of the big P in the Philippines, you've got Scarborough Shoal, which I think is valuable to highlight because the standoff.
That's this area here.
The standoff that happened in the spring of 2012, I believe it was.
Sure.
In which Philippines Coast Guard arrested several Chinese fishing vessels in that area for extracting large clams. Chinese Coast Guard showed up on the situation. There was a standoff for several months. There was press reporting that the U.S. helped kind of broker a deal where both sides agreed to pull back. But then the Philippines did pull back and China did not. And so some have argued that one of the things was that the U.S. Didn't necessarily come fully to the defense of the Philippines in that situation, and was potentially one of the reasons why the Philippines decided, hey, we have to look at other potential courses of action, one of which was they filed the arbitration case before an in-clause arbitral tribunal.
Yeah, I think pretty clearly it was one of the triggers of the arbitral tribunal. I mean, in addition to the fact that it was filed the very next year, I think, and was a substantial portion of what the Philippines had filed. Can you give us kind of a thumbnail sketch of what the arbitral tribunal decided was appropriate in the region? We can come back to a visual picture of that later, but maybe just a quick thumbnail sketch now.
Yeah, I think one of the valuable things was the legal team that the Philippines hired are seasoned in international law and maritime dispute cases, and they were able to navigate the language of the convention to make sure that they were not trying to put issues before the UNCLOS tribunal that the tribunal would not have jurisdiction of. China refused to participate, but the tribunal has the final word on whether it had jurisdiction or not, and it determined it had jurisdiction. So it looked at a number of issues involving the application of the UN law of the Sea Convention, and none of these were about who had sovereignty of any of the features. It essentially said, regardless of who has sovereignty of the feature, is this feature entitled to a 12-mile territorial sea or not? Is it a submerged feature entitled to nothing? Or is it a rock, at least a rock, which would be entitled to a 12-mile territorial sea? And then are some of those features entitled to a 200-mile exclusive economic zone? So the tribunal looked at those issues, determined that several of those features were submerged and they were not entitled to anything. Several of the features were I guess the remaining features were only entitled to a 12-mile territorial sea. And none of them satisfied the definition of a full-fledged island that would be entitled to a 200-mile EEZ. One of the other issues that was put before the tribunal was, what about this 9-dash line? China's 9-dash line, which started out as an 11-dash line back in the 40s under the Republic of China. Then the PRC adopted it in the late 1940s, and then they erased a couple of dashes over to the left of the Paracel Islands in the Gulf of Tonkin as a tribute or an accommodation in their relations with Vietnam. This was in the 50s, I think. And so the result was there was just 9 dashes. And then a few years back, they added a 10th dash between Taiwan and the Philippines, just a message to everybody, oh, by the way, Taiwan belongs to us. So the Philippines, one of the issues they put before the tribunal was said, is this 9-dash line claim valid under the law of the Sea Convention? And the tribunal ultimately said, well, if we're going to address it as if it is a maritime claim. China has never clarified exactly what it means. Is it just a claim to all of the features that are located within the lines? That is, all of those islands that happen to be within the lines, China's claiming sovereignty in it. Or are they claiming some sort of special status of those waters? China had not clarified, but some of the language and some of the actions that China had engaged in looked like they were claiming some sort of special status to all of those waters. The the UNCLOS tribunal looked at that and said, yeah, under international law of the sea, that's not a valid claim. So they invalidated the 9-dash line, which I think was one of the most significant elements of that arbitral decision. And I think it's one that most of the claimants look at and say that's completely sound within international law. Outsiders, academics look at it as well and say, I don't know of anybody other than someone within mainland China that defends the 9-dash line as being some sort of legitimate claim.
Yeah, we'll come back to that. I mean, I think it's really important that we recognize that that there really were 3 big outcomes of. I mean, there's a lot that the tribunal decided, but there were really 3 big outcomes. The first is that this sort of that the 9-dash or 11-dash, 10-dash line really has no basis in international law, despite China's claim of some sort of historic approach to its authority in the South China Sea, right? So that's the first big outcome of the tribunal. The second was that there are no features among the Spratly Islands that are entitled to an exclusive economic zone. That was the second, I think, really big outcome. Why? Because in the end, what it does is it says, okay, well, those features, as Jonathan, you pointed out, those features that are above water at high tide, those features are small bits of territory, and they're entitled to a 12-mile territorial sea, but not to an exclusive economic zone. So what it essentially did was it enclaved each of the little Spratly Islands, and in doing so, it allowed for the third, I think, major outcome, which was to simplify the complex claims in the South China Sea and allow law to operate in a rather straightforward manner to divide up the waters of the South China Sea. So I'd say those were the 3 big outcomes of the tribunal. Unless there's something you want to point out about this chart, let's move on to the next. Okay, so because I think it follows on, right, from this this idea that there's a legal approach, and the Philippines used the law to try to address the claims of its claims in the South China Sea. But there are other approaches, and China certainly is taking another approach. I should say that China's first response, well, really second response to the South China Sea arbitration, its first response was to choose not to participate, as you've said, and to deny the arbitration's validity. But its second response essentially was a power-based one, right? It built bases on I think 7 now of the features in the South China Sea, three very large bases, and then 4 smaller supporting bases among its occupied features in the South China Sea. So really a power dynamic rather than a legal dynamic was China's response to the South China Sea arbitration. So what do we see here about legal gamesmanship in the South China Sea?
Sure. So the idea of legal gamesmanship is something that I've been writing and speaking about in the past 2 years. There's a lot of discussion about lawfare, primarily in the U.S. academic community, and now it's gone around the world as well. But I steer away from using the phrase lawfare because in speaking with audiences that are not just people in the military, they kind of tune you out. If you turn everything into a military issue by using lawfare, then it's kind of like, well, no, they're not using their military, and you're like, well, but they are engaging competitive behavior. They are using the law in certain ways. And so I think there's that. And, China has within their military doctrine, they have a concept of the 3 warfares, which they announced, I believe, in the Political Works Regulation back in 2003. So not long, like 2 years after the General Dunlap, a U.S. Air Force JAG, coined the term lawfare in 2001. In 2003, China started developing this idea of legal warfare, which they also said using the law as a weapon. And so, but at the same time, it's hard to always say, is this action by China, are they doing what they think is legal warfare? And I think it's more appropriate to a more encapsulating phrase like legal gamesmanship. And how I define legal gamesmanship is conduct by a state or attributable to a state in which they use the structural, the normative, or the instrumental functions of law to achieve a political objective in a competitive environment or a competitive relationship with another state. So it sounds fairly encompassing, but the goal is to address certain behaviors are not always done by a military. Certain behaviors might be done in an informational effort, might be done in a diplomatic effort or an economic effort, which have a legal component to them. And so I think it's more appropriate to talk about legal gamesmanship. So when I talk about structural, what I mean by that is within the international structure, the rules-based international order and the institutions within that order, leveraging those, the rules of those to their advantage. Examples being, and once again, I mentioned earlier, the 50th anniversary of the PRC taking the China seat in the United Nations, and with that being one of the 5 permanent members of the UN Security Council. In fact, if you look at the language of the UN Charter, interestingly, the original language says those 5 members will be, and it lists all 5 of the countries, one of which is, end quote, the Republic of China, which is the legacy language that's in there. But nonetheless, what we see is one of the things is China leveraging the Security Council, obviously with its authority to veto as one of the permanent 5 members under Article 27 of the Charter, which is not something that they only do. The United States, the Soviet Union, and now Russia have vetoed Security Council resolutions before, but they're taking it to another level. And what I mean by that is in August of this year, when India was the rotating president of the UN Security Council, they scheduled a meeting of the Security Council focused on maritime security. And in that meeting, each of the member states of the Security Council at that time made speeches about what they viewed as concerns in the world about maritime security. And Secretary of State Blinken for the United States, in his statement, made reference to the South China Sea situation and the Arbitral Tribunal ruling. And the Chinese representative at that meeting said that South China Sea is an entirely inappropriate issue to discuss at the Security Council. But if you look at the language of the UN Charter, it says that the 5 permanent members can veto a resolution dealing with things over in, except for Chapter 6, which is the peaceful resolution of disputes. So setting aside use of force issues, if we're just talking about doing investigations and calling upon countries to resolve disputes that they might have, whatever types of disputes they have between states, that is within the purview actually of the Security Council. They could consider it. And so China's saying, no, it's inappropriate to cover it. No, it's not. They might not want that, but it is allowed. And so leveraging that, try to do that, keep it off the table. And another example is the using of structural, leveraging the structural aspect of the rules-based order. There's an emphasis by China. They want to negotiate bilaterally with the claimant states. But this is legally, this is an impossibility in this situation. And what I mean by that is the language from the Vienna Conventional Law of Treaties says two parties cannot bind a third party without that third party's consent. And a number of those island features that we talked about on the previous slide were claimed by more than two claimants. So China and the Philippines could try to negotiate the sovereignty of the Spratlys, but Malaysia would not be having a seat at the table. And Malaysia would not be bound by that agreement that China and the Philippines would enter. In addition, China wants to avoid using the international tribunals to address any of these disputes or any of these situations when they are lawful mechanisms to use. But at the same time, China has continuously put their judges on the International Tribunal for the Law of the Sea, on the International Court of Justice, to adjudicate the disputes of other countries, including the maritime disputes of other countries, but China is unwilling to allow their disputes to go before those tribunals. So those are examples of leveraging the structural function of international law. We can go into how they leverage the normative function of international law. We can go into the instrumental if you want to, but I welcome your feedback on the first thing that we just discussed.
Yeah, no, I think it's a terrific framework. Actually, I'd love to hear some of your thoughts about both the normative and the instrumental use of law. And then we've already got a question. Jose Alvarez is complimenting your overview of the South China Sea challenges, and he's got three questions at least. So perhaps you can say more about the downsides of using this concept of lawfare on this issue, and might lawfare actually escalate the conflict rather than render some sort of resort to dispute settlement more likely. We'll take it from there.
Sure. No, I think, and that kind of actually takes me to one of the other two ways, the instrumental, because that's one of the, when we talk about lawfare, really a lot of times what observers are talking about is using the law as a weapon, using it as a tool to achieve certain objectives. And that can be to include enacting new laws, new national laws. And so a number of the examples that I would highlight of China's instrumental use of law to achieve its political objectives in the South China Sea are the national laws in which they've made their maritime claims off their coast, and the breadth of their territorial sea, which coastal states do, or the breadth of their exclusive economic zone. But it's then in those same laws where they try to restrict the lawful activities of other countries. And so in addition to it, so from a non-claimant perspective like the U.S., we have challenged those maritime claims for years, the excessive aspect of those, trying to restrict lawful activities, the right of innocent passage through the territorial sea, for example. But in addition, other countries have a concern about the impact it might have on the sovereignty, the competing claims. And what I mean by that is, if I'm China and I enact a particular the law of island protection law, which was from 2012, which allowed China to take certain actions to protect its islands in the South China Sea. And if it lists off all of those islands in the statute and the regulations, on the one hand, you say, well, thank you for being clear or clarifying to a certain extent what your claim is. But the downside of that lawfare is now it's locked in their statutes. And it's really hard to negotiate with the other claimants to actually resolve the situation, to resolve the disputes. And oftentimes, one of the things I talk about is, for example, China's preference to avoid going to an international tribunal to resolve these disputes. But the reality is there anything that Manila could say to Beijing, or that Kuala Lumpur could say to Beijing that's going to convince them that their claims are superior? No. Is there anything likewise that Beijing's going to be able to say to those other countries that convinces them that their claims are superior? No. So if that's the situation, and if all of the countries have a certain level of nationalism that they told their people they're going to defend these claims, the best way forward, the only real way forward, is to submit it to some sort of third-party dispute mechanism like a tribunal.
Yeah, Jonathan, this, I think it's fair to point out that all countries, to one degree or another, attempt to stretch the law to to achieve their national interest. I mean, this is essentially why you have opposing claims, opposing views about how the law should be applied in any particular situation. And sometimes more powerful countries feel they have more stretch room or should be given more stretch room in how the law is interpreted. But I think the thing about lawfare or legal warfare, really, remember the Chinese actually have this term, fa lu zhang, which is legal warfare. And I apologize for my poor pronunciation, but the idea is that really the Chinese seem to have this idea of stretching the law to achieve their interests in ways that are just excessive. The way I like to put it sometimes is that, in some occasions, the PRC uses the language of the law, but not the law, right? So there are areas where the law is quite clear. For instance, when you accede to the convention, you are required to abide by the decisions of the tribunal, including the South China Sea Arbitrational Tribunal. And China wrote a 500. You pointed this out to me recently. China wrote a 500-page response to the arbitration, right, in the language of the law, but which really did not reflect the law at all. I think this is an important point to make about lawfare, legal warfare, and legal gamesmanship, right? That there is some that is legitimate and some that just is beyond the pale.
Yeah, well, I think that's why I prefer it, because one of the negatives, and this isn't about me trying to sell the bumper sticker legal gamesmanship, but one of the concerns I have in overuse of legal warfare or lawfare, or primarily lawfare, is it's a pejorative. It's what the other side does. Yeah. I don't do that. Only you do that, and that's my problem. When the legal gamesmanship is more neutral and says, hey, countries are in a competitive environment. There's certain things that they're going to try to do to their advantage. And some of those things are completely lawful. China vetoing a Security Council resolution, if one came before it, dealing with the South China Sea, would be perfectly lawful for them to do. That would be legal gamesmanship to do it. And if and so as a result, but what the point you bring up is, when is it that certain things cross the line?
I'm glad you mentioned that. I think
there are objective ways to look at things to say that there's certain types of legal gamesmanship that are in fact a violation of the rules of the game.
I like your construct a lot, Jonathan. I maybe as much as 10 years ago, I gave a talk at the Brookings Institution called Street Fighter Soccer Match. And really the idea basically is, we can engage in international disputes, sometimes with sharp elbows. And that's the soccer match, right? The soccer matches, as we all know, and football for our European friends are they're also pretty rough matches at times. But everybody walks away and comes back again to play again. And there's a set of rules, and it's competition with rules. The alternative to that is essentially competition with knives. And a street fight among rival gangs is one in which people bleed and die. So really what we're talking about is the value of rules in international discourse, and the idea that even as countries pursue their national interests, using the rules sometimes instrumentally, sometimes looking for ways to use the structure of the international system to their benefits, that's good gamesmanship, and that's legitimate. It is different, right, from the power-based approach where you might claim legitimacy in the language of the law, but really what you're doing is sticking a shiv in your neighbor. So that's the distinction that I think is important to make. Do we want to talk a little bit more about the other two, the instrumental and normative?
Yeah, the instrumental, I tried to touch on that a little bit, talking about that there a number of laws over the past 30 years or so that China has enacted, in which national laws in which they've tried to leverage those, and so therefore, when a country engages in behavior that might be lawful in international law, you'll see the talking points that come from China's Ministry of Foreign Affairs saying country X, oftentimes it's the United States, they are violating international law in the South China Sea, and they're violating Chinese national law. But if you look at the language in the convention, there are almost, I think, a dozen occasions or so where the convention says user states have an obligation to respect or maintain due regard for the coastal states' laws that are in conformity with this convention international law. So it doesn't mean that a coastal state can just enact whatever law it wants to. They have to make sure that their laws are in conformity with it. So it creates another kind of element of argument in the battle of the narratives of, hey, you're violating not just international law, you're violating our law. And so there's a problem there as well on the instrumental side. When it comes to the normative, I think there's a number of different norms that normative gamesmanship that concern me. One of them is that back to the user states and the U.S. and other countries engaging in military activities in the EEZ, for example, in China, off the coast of China. And China's argument that violates international law by those countries engaging in that activity, when, as I said, the EEZ is an exclusive economic zone. It's not an exclusive security zone. There were, as you know, there were a handful of states in the UNCLOS negotiations that wanted for it to be a security zone, and China early on in the negotiations wanted there to be a 200-mile territorial sea. But that didn't happen. The compromise that was agreed by the negotiating states was it's for your economic resources, not a security buffer. And so China for years has said what the U.S. is doing in its EEZ and over its EEZ violates international law. But as China has gotten to more and more of a blue water navy, we now see China engaging in military activities in the EEZs of a number of countries, including the United States. And so a few years back, I was speaking at a conference in in Canada. And the topic of the conference was South China Sea and Arctic. And I'm like, that's apples and oranges. They're really not two real similar situations. But then I realized, no. They actually are, from a U.S.-China perspective. One's a home game for one and an away game for the other, and the other was an away game for the vice versa.
Yeah.
And the value is that there's one rule set. It's an international rule set. And so avoiding the risk of double standards validates the rules-based international order. Allowing double standards is the problem. And so not allowing China to say, oh, you can't do that in my EEZ, it violates international law, but yet China engaging in that behavior. Likewise, the U.S. needs to maintain a consistent position and say, and they have, to the extent I know, government officials in the U.S. government, when China or Russia and previously the Soviet Union operating off the coast of the U.S. in our EEZ said they've got the freedom to be there. We'll monitor them. Maybe we'll intercept them. We're going to do it safely. But a lot of times we don't even waste the time to intercept them. So,
before we get to the next slide, Jonathan, I'll give a quick preview just so I recall what it is. Yeah, that's good. I'm going to stop sharing my screen for a minute.
Sure.
And what I want to do, you can see me again. What I want to do is ask you about this, the whole concept of legal gamesmanship and the normative, instrumental, and structural aspects of law. Some would say you and I, as representatives in a sense of the United States government, we've got no right to talk, right? The United States has declined to join, to accede to the United Nations Convention on the Law of the Sea, at least to date. You and I are both on record as saying that the United States should have done decades ago, join the convention, but still the government has not. And so there are some who would criticize and continue to criticize the United States for essentially this double standard. So first of all, what do you think about American accession to UNCLOS? And then, do we have a leg to stand on when we criticize others for failing to abide by it?
Well, I as you said, I've long viewed that we should join it. I think it's a significant failure on our part as a nation for several reasons. It's in our best interest to do so. And before I kind of elaborate on that, I think one of the key things for me to highlight is actions have consequences. And when we talk about gamesmanship, the U.S. might decide, for whatever reasons, a number of senators have decided they don't want to vote in favor of the U.S. succeeding, even though a number of presidents in both parties have supported the U.S. joining the convention. Clearly, it takes two to tango. You have the Senate and the president approving it, but a number of senators have opposed it, but because they think it's not in the best interest of the U.S. But the result is a lot of opportunity costs for the U.S. and there's essentially consequences. So, for example, because the U.S. hasn't joined it, the U.S. can't put a judge on the International Tribunal for the Law of the Sea, who, in the current cases that are pending before the tribunal, are applying international law, developing further international law, and the U.S. can put its head in the sand and say, we're not going to follow it, or we're not going to be a party to this convention. But the ship continues on. Meanwhile, China and Russia have continuously had judges on the International Tribunal of the Law of the Sea since its birth in 1996.
Yeah, this is a really important point.
Yeah.
The law is developing
whether you like
without American participation. It's in the International Tribunal for the Law of the Sea, but also in places like the International Seabed Authority and others.
Sure, exactly.
It's marching along. Yeah.
The Extended Continental Shelf Commission. We also don't get a seat at that. All of these are back to the structural aspect of international, but because we've decided to not become a party, these are all opportunity costs. These are all risks that are we willing to assume these risks to let the law continue to develop? And one of the arguments why we shouldn't join by opponents is it's going to give up some of our sovereignty, which arguably every treaty in some way accommodates a nation's sovereignty because they're making some concessions about things they would have otherwise been able to do forever. But it's not necessarily negative because it's a bargain in each of these treaties. And there are a number of multilateral treaties to which the U.S. is a party, of which those opponents would say, oh no, we should be a party to that one. And so there's this allegation sometimes that if we joined, all of a sudden we're going to get sued for environmental regulations or environmental violations or climate change, or the U.S. is going to get hauled before the International Tribunal for all of this myriad of cases. When the International Tribunal of the Law of the Sea has only had 26, 27, actually I think it's 28 cases at this point. But the point is there are a number of countries that have perspectives that are aligned with the U.S. perspective on these issues, but yet they're not getting sued. They're not getting hauled in. So it's a kind of insulting to intelligence to say that the sky is going to fall if we join, to the 166 or 167 nations that have joined, because the sky hasn't fallen for them. So I don't think the sky is going to fall if we don't join, and I don't think it's going to fall if we do join. But all things being equal, I think we should join. I think one of the reasons strategically it sends a message that we're all in when it comes to this rules-based international order that's post-World War II order that we helped develop and codify. And it's to our advantage to uphold that order. We have some of the largest maritime interests in the world with one of the largest EEZs around the world. We want to
Isn't it the largest, right?
Yeah, well, it's debatable between us and France. But with regard to the extended continental shelf and the Arctic, we would love to be able to, we would want to protect that. U.S. industry is not drilling in that area because they don't have the assurances that if they locate and find some stuff, that there's going to be some sort of wildcatter come and take over the resources that they just spent the blood and sweat and tears to invest in. So,
yeah, you've pointed out actually one of the driving forces across the 20th century for the development of international law of the sea, which is that businesses need certainty that if they're going to harvest the seabed resources, either whether it be oil or nodules or whatever, that they're not going to put the money into R&D or searching for these resources, and then somebody else comes up and takes their claim. So that certainty to business is one of the major drivers of law of the sea over the course of the 20th century, and should be a driver in the 21st. So first, the next question I've got for you is, all right, so what's the likelihood of accession at this point? What do you think?
In the near future, slim to none. Probably the emphasis on none.
That's unfortunate, but we can still soldier on.
The reality is the last push was in I believe 2012, and there were 34 of the senators that opposed it at that time. that signed a letter that said, if you try to bring this to the floor, we're going to block it. And 34 is the magic number because you need 2/3 within the Senate, as you know, to provide advice and consent on a treaty. So if you can get 34 opponents, then it's dead in the water.
So, all right, then I come back to the original question.
Senate.
Sorry, what's that?
22 or so of those members are still in the Senate. So there's been some changeover. The irony, I will bring up, the irony, in my view, is that in the past 5 years, there's been a number of Senate resolutions or statements by senators on the anniversary, for example, of the Arbitral Tribunal ruling, which they said China refuses to follow that ruling. And those are individuals that either voted against joining the convention, or they would probably vote against joining the convention.
Well, that is ironic, but so I come back to the original question, right? Which is, who's the U.S. to talk on this issue? What gives us standing?
Yeah, well, I think one thing is what the executive branch of the U.S. government has made clear for years is that we follow most of the provisions of the Law of the Sea Convention as a matter of customary law on a consistent daily basis. The navigational provisions, the coastal state claims. The U.S. doesn't try to claim more than 12 miles territorial sea, doesn't try to claim more than a 200-mile EEZ. The U.S. respects coastal state laws that conform to the language of the convention. And so the U.S. follows it as a matter of custom. Now, some will argue, well, you said they don't follow all the provisions. They don't view all the provisions as customary law. Well, a perfect example is the U.S. is not a party, so they don't get to put a judge on the tribunal. That's not a provision of customary law. If it was, hey, if everybody viewed that as customary law, then the U.S. would start nominating judges. So I'm not trying to be too cute by half to say that.
No, I think it's fair to say that, first of all, it's important to recognize that Ronald Reagan actually is the one that signed the executive order directing the federal government to abide by those provisions you referenced of the United Nations Convention on the Law of the Sea. And for now approaching 40 years, that executive order is still in place. And additionally, the United States, as you've mentioned, has accepted frankly, I think rather expansive aspects of the United Nations Convention as being customary international law, particularly those that divide up the ocean space according to sovereignty, sovereign rights, and international rights, and then also to those portions that are about the passage rights that sort of apply on a global basis. So, I mean, I think the United States has actually been very consistent in its approach to the convention, and I would also say quite normative in its approach to the convention. Maybe you disagree.
Yeah, no, one thing I was going to offer also as well is, one of the things when China refused to follow the Arbitral Tribunal ruling, and a number of their voices said the U.S. cannot lecture us because, look, they did not follow the 1986 Nicaragua versus U.S. ruling in the National Court of Justice, which is true. The U.S. didn't do that. But it's very convenient to highlight one case when the U.S., I believe, is right now has had 24 or 25 cases that it has gone before the International Court of Justice since its inception. And of note, the 1982 to 1984 case between the U.S. and Canada applied the language from the Law of the Sea Convention, even though the parties, it was not in effect at that time.
You're talking about the Gulf of Maine case.
The Gulf of Maine case.
Yeah.
So the U.S. did not get everything it wanted in that ruling.
That's true.
Exactly. And yet the U.S. respects that ruling. And Canada and the U.S. have the boundary resolved in that area. And so it's very convenient talking point to say, but Nicaragua, which the reality is the U.S. has also taken a credibility hit back then by not following that ruling, by pulling out of the case early and not participating in the ruling. So, China has taken a credibility hit, and that's just it. Actions have consequences. So
Yeah, no, that's fair. So that'd be a whole separate program we could do someday, comparing, the South China Sea arbitration and the Nicaragua case. But here, I do want to share my screen one more for one brief moment, and then I think we should move to questions pretty soon, Jonathan, because they're starting to stack up. And I would invite the audience to begin to consider questions. But I'm going to share my screen, and what I want to show, Jonathan, is the picture of the two different approaches to the South China Sea.
Sure.
Right. And maybe we can talk our way through that for just a couple of minutes before we go to questions. All right. So let's move here. Here. So, all right. So on the left, what maybe, Jonathan, you can explain to us what we're looking at on the left.
Yeah, I think on the left, setting aside the dashed line, what we're looking at is
you're talking about the red dash.
The red dash line. Yeah. Setting aside the red. Thank you for clarifying. Yeah. Setting aside the red dash line for a moment. The rest of those depictions, the blue dashes, illustrate what would happen if each of those coastal states claimed a 200-mile exclusive economic zone off of their coast. That you would have 200-mile belts of EEZ off of each of the coasts, and then you'd have a corridor of you see in the white of high seas freedoms in the center. And
yeah, so, can I pause on that point?
Yeah, sure.
Sorry to interrupt you.
Yeah,
right. Because this is how the law, international law, post-tribunal determination would divide up the South China Sea. Right. This is what we're looking at on the left-hand side. And one of the things that it includes is this. I like to refer to it as the high seas comma. Right. This large comma-shaped area in the South China Sea that is high seas, and which, as high seas, mean that every country has an interest in the structure, the legal structure of the South China Sea, and in, frankly, the South China Sea itself. So this area of high seas means all countries have that interest. Sorry, back to you.
Yeah, no, and so as a result, you see there that the claimants all stand to gain with certainty, just like in the situation, like for example, with Bangladesh and India, or Bangladesh and Burma. The chance to resolve these through the rules-based approach, they would stand to gain a large assurance of that's my EEZ, and I know that I can patrol it, and I can do what I need to do to regulate that within the confines, the limits of international law, and it creates predictability and certainty in the system, as opposed to this continuing uncertainty.
Yeah.
And what you also see is that if all of those small islands, in the Spratlys as well as the Paracels, if you took what the tribunals have done in other cases and enclaved them with 12-mile territorial seas, then that whoever's occupying it might in fact have sovereignty. If the tribunal, if they were to put all of those sovereignty questions before an arbitral tribunal or before the International Court of Justice, they might ultimately have sovereignty of those 12 miles around those islands that they have. But the result is the level of predictability in that situation would be massive. And countries can move forward. Right now, there's a lot of ungoverned space or confusion about government. And so, know that.
Yep. So this is what we were talking about earlier about one of the major outcomes of the South China Sea arbitration was the simplification of the issue and the then ready application of international law to the broader questions of how to divide up the water space of the South China Sea. And that's what you're seeing on the left-hand side is the outcome based on international law. On the right, what we're seeing, you see the 9-dash line, and so we've already talked about how China has what I refer to as the outside-in approach, right? The 9-dash line as being a boundary based on some sort of historical claim, that the outer boundary of is the 9-dash line, and then everything inside, based on history, belongs in some way to China. China uses the phrase jurisdictional waters, right? These sort of ambiguous phrases that are not part of the convention to describe its interests. The second, and I will refer to this as being completely notional, the second approach is the inside out, right? So one of the things that China did in the South China Sea in the Paracel Islands, that's this island group up in the north up here, is to draw straight baselines. And China has left some pretty strong hints that it intends to draw straight baselines around some or all of the Spratlys in the South China Sea. And so what I've done is actually a colleague of mine did this. Isaac Garden drew notional boundaries around some of the South China Sea groups. This is not to say that this is what exactly the Chinese would do, but it's a notional a grouping of those islands to depict the inside out approach, right? So using the language of the law, but not the law, as I said earlier, which is about drawing baselines around large groups of islands, in between which is vast amounts of water, which should be largely international in character. And so enclosing those in straight baselines, and then using those straight baselines, improperly drawn, to develop an exclusive economic zone that extends 200 miles from there. So this chart on the right depicts both the outside in, the 9-dash line approach to jurisdiction, and the inside out, that being the grouping of islands around with baselines and then claiming zones from them. So on the left, we have clearly the law, and on the right, we have something else, right? So these I thought were useful ways to help understand the differences, right, between what the South China Sea arbitration tells us should apply in the South China Sea and the ways in which, on the right, China has articulated their authority over the South China Sea. All right, I'm going to stop sharing. And
actually, can I make one point on that one? If you don't
of
mind?
course.
Yeah. So with regards, because I haven't commented on if you bring up that slide again.
Do you want me to bring it back up? Sure.
Yeah, if you don't mind.
No, not at all.
Yeah, the image on the right, which I know, like you said, is notional. Got it.
Yeah.
But I think you and I are reading the same things. A lot of Chinese scholars wanting to push forward this straight baselines theory. To what end? To what purpose? You know, if it's just within the waters around the paracel, within the paracels, or are you trying to do something more eventually? And that's the concern, is with the salami slicing tactics, the concern of trying, this is just a step to achieve something additional in the future. But one of the key things from the tribunal ruling, which we didn't discuss, was talking about artificial islands and enhancements. So what's the purpose? The tribunal said, it is what it is. Whether a rock is as a rock, you can't make it more. You can't make it a full-fledged island. A submerged feature cannot be made into a rock or a full-fledged island getting a 200 EZ. So
yeah, it is what it started out as.
Yeah, exactly. Naturally, it is what it started out as. And so
under the law, it remains what it started out as.
So that's one of those normative uses of gamesmanship if China is trying to do this. That's on the legal side. On the political side, you know, there's a lot of arguments that are made about, well, the U.S. presence in the region is destabilizing the situation in the South China Sea. These actions, by pushing forward this kind of a situation of, oh, we're going to draw straight baselines and then we're going to draw maritime zones for that, and potentially get, you know, very overlapping, like it is making the situation worse, not better, when it comes to resolving these disputes. So I'll stop there.
So yeah, okay, I'll stop sharing. But I want to point out at this point, Jonathan, you and I have been engaged now for I don't know, probably 4 years or more on a project which is also the title of our talk today, right? Which is Testing the Boundaries. It's this project where we're working through the U.S. Asia Law Institute to begin to work through a lot of these questions, right? Working with American lawyers and lawyers from East Asia to begin to work through these issues systematically, and to think about ways in which we can help use the law to reduce tensions in East Asia, the maritime disputes and the tensions that arise from them in East Asia. And I mean, the last year we haven't had a session of that, but we've done a series of workshops, and there's a report online at the U.S. Asia Law Institute website. There's both a report. There's a good forward by our colleague Jose Alvarez, who I know has joined us here. So Jose has asked about, given the disputes on the view, is UNCLOS fit for the purpose? In other words, in an ideal world, what reforms to that treaty would be helpful? While politically unrealistic, there are some who are re-examining the relevant UNCLOS rules, including a UK parliamentary expert committee. That's a great question. To what degree do we think, Jonathan, UNCLOS is ripe for revision?
Well, I think the probability is very low that you could get everybody back in the room to do any revisions. But I would argue that it as written, plus the jurisprudence that's come out of the tribunal, come out of the convention, gives a roadmap. And the project that you've been working on shows that there's a roadmap. And what I mean by that is, when we're talking about overlapping claims, the convention is clear that if there's less than 24 miles between two states, whether it be between their islands or whatever, you do a median line. And then it says if there's less than 400 miles between you, then it doesn't say median line, it says you'll reach an equitable solution. Mm-hmm. And the tribunals have looked at that and they said, generally, we're going to follow a three-step approach. We're going to draw a median line note, a provisional line at the beginning, in the middle, and then we're going to look at the factors to see whether that line equity says we should move it left or right. And then we're going to go back and look at it a second time to see if we did redraw it, how's that impact things. And I talk about it, I always often use the image of the carpenter rule. You measure twice and you cut once. Yeah. That's kind of like what the tribunals are doing in this situation. They start the halfway, they measure it once, and then they measure it again, and then they say, okay, we think it's equitable. And so you're not going to be, I don't think you would be able to find language in this day that countries could agree to better than equitable solution. And the reality is trying to think, one of the cases, actually, one of the tribunal identified that language, equitable solution, was a compromise just to get the convention past the goal line. To get
it. So I'm going to invite Jose to speak
sure.
On his own here in just a second, but I do want to point out something you said earlier, right? Which was that the convention came together at a fairly unique moment in history, right? Which was the late 1970s and early 1980s, where there was a convergence of interests among all of the major powers in the world at that time: the United States, Soviet Union, China, and the European states, the UK, France, et cetera, Germany. There was a convergence of interests at that time. Number one, we've already talked about the commercial interests in sort of getting some clear standards for how to measure continental shelves and the rights in them, and then also conservation standards around fisheries on a global basis. And then there was both the Soviet Union and the United States had strong navies at that time and a strong interest in maintaining passage rights for navies around the world at that point in time. And so you had this ability of the international community to come together to make compromises at I think, a fairly unique point in history. And so, as you say, getting the countries of the world together again to try to find ways to renegotiate key aspects of the convention would be a fairly difficult thing to do. I mean, I applaud the UK Parliament for working on the question, but I think what we talked about earlier, that sort of steady evolution of the law, is the more likely approach for the law to take. But it's really important to recognize that the vast majority of the evolution of the law occurs from within the convention, right? So through the International Tribunal of the Law of the Sea, through the International Seabed Authority, from the Continental Shelf Commission, et cetera. All of these are key ways in which the law is evolving. So I'm not convinced, Jose, that we do need to renegotiate provisions of the convention. But Jose, over to you. What are your thoughts on this, and what questions do you have?
Yeah, so I think Jonathan addressed a good chunk of the question by suggesting that the things that are in the convention that allocate or basically delegate power to the adjudicators, like equitable solution, is not something that we can change. And I totally agree that politically, at a time when we have treaty status, not just in the US, but around the world, we're looking at, in every area that I can think of, perhaps there may be a pandemic prevention treaty, but I'm not holding my breath on that one either. That is, there's soft law alternatives that states are going for, because getting the ambition together of a multilateral treaty is so hard. But I guess my question is partly driven by the pushback against judicial interpretation of treaties that we are now seeing in the WTO and investor state dispute settlement, to some extent within regional human rights. And so there's some worry that I think we have that the reaction that China had to the South China Sea dispute may start being imitated by other states that feel that these tribunals, whether it's ITLOS or the seabed or so forth, are going too far in their delegation of power, which is, I think, part of what motivates something like examining the primary rules versus what we delegate to adjudicators. And I guess part of the question would be, well, what about that dispute settlement options that we now have? We see China's reaction in not adopting this. And I think the reaction is not just about what it said about the 9-dash line and the merits, but the response to the jurisdiction, right? Which I think is a closer call, frankly. I do think that the line between adjudicating a territorial dispute and that is a more debatable proposition. And as is the question that I think is the heart of Peter's maritime project, which is, okay, if we have a menu of options, how do we get states to take up that menu? And should the menu emphasize more mediation, negotiation, or other alternatives, given the backlash that we now see to formal courts, formal multilateral courts across everything from human rights to trade to investment? And so I guess that leads me to the third question, which is just to invite Peter to say a bit more, especially for folks who are not as familiar with the project. What lessons, if you had to do a shorthand version before we all get exhausted and do 36 of these cases, is there a little toolkit of what might induce states to settle these disputes, even if they don't go to court, right, and get a formal judgment? What does it take? What do we learn from the successful cases?
Yeah, this is a great question, Jose. So, one of the things that I think is really important to recognize is the law is global, but the problems are local. And in order for the problems to be successfully resolved in ways that are lasting, there needs to be some sort of flexibility among the parties, right? Not the law itself, but between the parties about how the law will be implemented in this particular case. And there's actually a fair amount of latitude, right? So what you've got to have are parties that are interested in resolving the dispute. That's number one. That is the single most important factor, I think, which is that both parties are willing to resolve the dispute, even if they don't get everything that they need. The second is that one of the things that works really well in helping to prepare parties to resolve the dispute and to be willing to resolve the dispute is healthy negotiations. Sometimes these are contentious. Sometimes they take decades. But healthy negotiations in advance of a tribunal decision tend to make the tribunal decision more likely to be binding. Don't get me wrong; there are good reasons at times for resort to a tribunal even without these circumstances. I think the South China Sea arbitration is actually one of them. There have been decades of negotiations of one type or another in the South China Sea, of discussions, of talks, et cetera, that have gotten nowhere. And I think essentially because there is, as we showed earlier, such a extreme difference between the parties about how the disputes should be settled in the South China Sea. But the law in that case or resorting to the law in that case, at least has clarified what the law, what international law has to say about the subject. And that's a pretty powerful tool, I think, for the Philippines, because prior to that, what the law would actually say on the topic is a subject of dispute, or it's a subject of contention, or a subject of opinion. But now we know what the law has to say. And so there's a clarity that has been brought to the conversation, and frankly, a certain legitimacy that has been brought to the conversation that I think is an important outcome of that arbitration. So, getting the parties to resolve the disputes, one of the things that we've, as I said, that we've seen is that it takes long periods of negotiation. There's actually one other factor that seems to have an important contribution to resolving disputes, and that is in South America in particular. There's a region-wide treaty to resort to arbitration and to resort to the International Court of Justice to resolve maritime disputes, or to resolve disputes generally. And so it hasn't been, that treaty hasn't been fully honored, but it has done a pretty good job of bringing states into adjudication on their claims, and then I think it's more likely that states will abide by the outcome because they've already decades ago agreed to abide by the outcome, and to put international law and tribunals that decide it at the forefront of the outcome. So those are the three things that I would say. One is a sort of political willingness. The second is long periods of negotiation with an eye toward resolving the dispute. And the third would be these sort of external structures, all of which in the end allow for legitimacy. Even if a state doesn't get everything it wants, it proceeds in legitimacy if these factors are in place. So thanks for the question, Jose. I want to actually move to our friend Min Trong, who's asked a very interesting question here in the Q&A. She said some scholars have argued that the South China Sea arbitration should take into account historical and regional laws or rules, like the ICJ did in some occasions in other regions. What do you think about the admissibility and applicability of these issues? Jonathan, I know you've looked carefully at the Eastern Greenland case, which did take some of this type of factors into account. I've looked at the Eritrea Yemen case very carefully, but I see some distinctions there. What do you think?
Yeah, well, I think to say history is not relevant to the situation from a legal perspective is not accurate. That it's imprecise. And what I mean by that, and if we talk about the categories of disputes, on the question of maritime zones or overlapping claims and those aspects, in general, you're applying the language of the convention and the jurisprudence of the tribunals, of the courts and tribunals, right? History is not relevant. So a 9-dash line doesn't matter, because when the tribunal said when China signed up to the Law of the Sea Convention, it gave up any kind of potential historic right claim or something like that. But when it comes to the questions of sovereignty, of who has sovereignty over a particular feature, history is relevant. And the tribunals look at that. Going back to the Isle of Palmas case, the arbitration case that the U.S. was a party to, that the U.S. lost, actually near the South China Sea, and the U.S. respects. You don't see the U.S. In control of the Isle of Palmas at this day. That's part of Indonesia, historically. But the point is history is relevant in that sense, because you look at who discovered the feature, when did they discover it, how did they acquire it, what's been the behavior before it became a dispute. Once it's become a dispute, the courts say there's a critical date. You can't look at anything after that. The history is not relevant at that point, any points at that point, because it looks like the parties may be trying to pad their evidence record. So looking at the history about when they discovered it, how they acquired it, that is relevant in the situation. So I think that the bottom line on this is I think the law compartmentalizes in that way. And so if you were looking at the sovereignty disputes, you would look at history, but it's a really slippery slope, a dangerous path to go down, I think, to start saying, oh, we should look at history in general in the South China Sea situation.
This gets back to your construct of the three aspects of how law is used. And it also relates back to, my point about what makes legal outcomes more likely to be binding, right? So I looked at this.
I would throw in, you said more likely to be binding. They are binding.
Yeah.
To be followed.
Perfect.
You said earlier, said it'd be more likely for it to be binding, and that was the problem with the Philippines case. The ruling is binding. It is as a matter of, I'm not trying to mansplain to you.
No, you're absolutely right. Thank you for pointing that out. I should have used the word to be accepted by both sides on a permanent basis, right? So to be binding as a matter of law, you're absolutely right about that. Thank you for the clarification. So in answering Min's question, it's this question of I've looked at the Eritrea-Yemen arbitration actually very closely, right? So this is a situation in which that there was regional conflict, there was civil wars, there was and then there was frankly conflict between Eritrea and Yemen at various times over their interests and claims in the Red Sea. And it really became a serious international issue because of the importance of the Strait of Bab el-Mandeb and the Red Sea as a key waterway, a key global waterway en route to the Suez Canal. And so many international parties got involved to engage in negotiation and to sort of get the parties talking to each other. And they were, in the end, they were quite successful. And they brought the parties to arbitration. But the key was that it was arbitration on the terms set by the parties.
Right, exactly.
Right. And that is the real key to what I think made it well, even this, it's not clear, was fully successful in having the parties accept the outcome, but still we got to an outcome that has been at least stabilizing in the region. And the point was, it was arbitration on the terms set by the parties, and that term set by the parties allowed the arbitrators to take into account historical practices in the region. Now, the law wouldn't normally have taken them into account in the same way that the arbitrators were allowed to do so because of the terms provided by the parties to the arbitration. And so I think that's a really important thing, that the arbitrators were given the right to decide what an equitable outcome would be given historical regional practices. And so they allowed, through the structure of the arbitration itself, to bring in aspects of factual practices that would not have been as strongly considered if it had gone to the ICJ with no preconditions, just, hey, apply the law to the south or to the southern part of the Red Sea. And so I think this it answers Min's question in part by saying there are ways to bring in historical practices into dispute resolution mechanisms. It depends on how the parties work together cooperatively to frame an arbitral tribunal, and sometimes this takes many years of negotiation to accomplish. So I'd like to look at some of the other questions. So yeah, we're privileged to have Renato Cruz de Castro asking us questions from the Philippines. I'm so glad to see that we've got such eminent guests here today. And so Renato's first question, he's actually got three here. Two, asking what are the legal, diplomatic, and strategic implications of the Trump administration's decision to make the arbitral ruling the basis of U.S. policy on the South China Sea. I don't know. Do you have thoughts on that, Jonathan?
I do. Yeah, I think that was a very significant statement that was made by the U.S. government last year. And I think it was I applauded it as a step forward in the situation, because for the longest time, the U.S. the nuances of U.S. policy were getting lost. So the U.S. said, we're not going to take a side on the ultimate issue of sovereignty, who has sovereignty. We call upon the parties to resolve the disputes by peaceful means in accordance with international law. And Beijing used that as to drive a Mack truck through it and said, the U.S. said they're going to stay out of these disputes. So we can make whatever absurd claim we want, and the U.S. won't take a side. But instead, this statement that the U.S. issued last summer said, James Shoal, it's 20 meters below water. There's no sovereignty there. Why are you doing sovereignty oaths around that water space? That is in the Malaysian EEZ. And that's a perfect example. So to say, yeah, there are claims, and then they're really absurd claims. So if you're claiming sovereignty to something that's not there, then that's an absurd claim. And we're going to, and the ruling that it reinforces things that are in the ruling. And so as a result, I think that was a positive step. I haven't gotten any kind of indication as to what I read publicly about the U.S. government that the Biden administration is moving off of that statement. That's kind of my perspective in a nutshell.
You know, one of my former students is Nat Chan. He's a Singaporean naval officer. He's come in with a question, a terrific one, I think, which is, you know, we've seen a whole lot of naval exercises in the South China Sea, you know, by all parties concerned, right? So China and Russia, U.S.-led Quad, Five Powers Defense Agreement. He points out, in fact, he says he's participated in some himself, but he wonders, has internationalization of the dispute and the growing competitive environment only further entrenched China's approach to the problems, or is there some positive effect that we can see from this dynamic? What do you think?
Great. It's a very challenging question, but I think it's a great one to ask.
He was a terrific student. You can see why.
Exactly. So, and I think that, you know, you and I have often said that, for example, just from a U.S. perspective, FONOPs are not a strategy. A mere transit, that does not constitute a South China Sea strategy of a vessel. And if you do joint exercises, that just continuing to do military exercises and things like that isn't necessarily a strategy. It's to what end? And I think, you know, one of the ways there has to be a comprehensive approach in this situation, right? You have to use the diplomatic, the information, intelligence sharing, things like that. So how do you make sure, the bottom line from my perspective is, the objective is to ensure that the countries can resolve the disputes peacefully in a voluntary manner, right? That a Malaysia or a Vietnam or a Philippines, they don't have to go to a tribunal to resolve these disputes. But what they do need to have is peace of mind that they have an equal voice in the discussion in resolving these disputes, that they're not being forced, coerced, arm twisted into accommodating a deal that's not in their interests. And so what is it that when it comes to joint law enforcement patrols, for example, if a country is doing joint law enforcement patrols with the Philippines or with Vietnam or with Malaysia, to message, no, if the tribunal said you're entitled to an EEZ off your coast and not a 9-dash line, and activities is happening in that overlapping area, then countries could be doing joint patrols with that coastal state to reinforce the capabilities that they might have gaps in, right?
Yeah. So I've got some thoughts on this too. The first thing I think is to say is, to the extent that the exercises are about law at all, rather than sort of power signaling, right? Which is an important look. This is part of the international system, and it's part of what's going on there as well. That there are large, international interests that are at stake, and they're signaling in relationship to those broader interests. But to the extent that these exercises are about the law, I mean, one of the important things that I think they do, we showed earlier with the two different sort of approaches that there is one approach in which there's a an open legal order, and the other would tend to push it towards a more closed legal order. So mare liberum, mare clausum, as different approaches to legal order. And so we talked earlier about the way in which the United Nations Convention on the Law of the Sea enshrines that open legal order as an essential component of the negotiation between, user states and coastal states and their sort of divergent interests. And it came up with a pretty solid compromise that's largely, I'd say that's been widely accepted on a global basis. And so it's that open legal order, to the extent that those exercises are about law at all, it's that open legal order, I think, that is being preserved. And there's a relationship between the political signaling and the intent to retain that open legal order those signals are being sent at the same time. And so, that's why I like those two side-by-side comparisons, because they really show the distinction between what an open legal order looks like and what a more closed legal order looks like. Now, some would say, well, how do you know that's a more closed legal order? Well, in part because of the way China's domestic legal structure imposes more and more coastal state authorities under the zones that it claims it has an interest in. And in part because of the way that they've designed the zones. So we need to think about those exercises in the South China Sea in the context, not just of the power politics, but also of the legal politics that are at play as well. All right, Jonathan, we're just about out of time. And so I want to give you the opportunity to make any closing comments you might have.
Oh, okay.
Surprise.
No, I welcome anybody reaching out to us later for questions and further conversation on this. Obviously, these disputes will continue to exist for the foreseeable future. I'm not naive enough to think they're going to wrap up and resolve themselves, but I think that a lot of the law is fairly clear, or that it exists and addresses these issues. It's less about an issue of whether the law provides an answer and more about the political will on multiple levels to apply that law in many respects.
Terrific, Jonathan. Thank you very much. It's been a privilege. This went by, 90 minutes went by really fast for me. I hope it did for the listeners as well. But the opportunity to chat with you about these things is always a privilege for me. Thank you very much for joining us. And I, on behalf of the audience who can't voice their appreciation, I'll do it for them. Thank you very much for your time and for your great insights. I appreciate them very much.